It's a civil appeal coming for the first time. There has to be formal admission for staying the operation of the internal order pending dispute with the appeal.
The eviction order.
Yes.
Have you served notice?
Civil appeal, normal practice, rather CPC has full applicability. Unless this court directs me for issues of visual notice upon the respondent, the respondents have no right of audience.
Okay. Have notice. Were you?
Requires some time by location.
They are appearing.
The order has to be stayed for this operation. The legality and propriety of the eviction order, not in an identical matter, benefits interim protection.
No, at that time I had the opportunity to hear the other side.
Civil appeal not news.
But is the order against injunction order against government?
Even here also the airport authority passed the eviction order.
Oh,
They have no right to do so. That's a matter of hearing. But prima facie, I'm in possession. I'm possession over the land in question. They have granted eviction. P10 may kindly be seen in order. P10.
E10.
P10.
Yes.
Not to see. I'll take loss of the operating portion at page 46, clause 9.
Yes.
In view of the above finding, it is hereby held that the respondents are in unauthorized possession of land belonging to the airport authority located at number 9 according to the following charters are passed. The respondents are dashed to vacate the said land and remove all unauthorized structures, encroachments or belonging to the case from date of usage of this order. Failing to comply with this, it will result in AIR taking necessary action, including forcible eviction, not calicy, in accordance with the provisions of the airport authority act. Now, the land in question is a government revenue land. It's a government revenue land. I'll show that. If it is a government, because I have my own recorded property.
So
They
you
say,
are an unauthorized
no, I
occupant.
mean occupation of my property which is recorded in my name. The airport says, not kindly see, I'll show my papers. Airport authority says the adjacent land belongs to airport authority. But the records would show it's a revenue land. If it is a, no, this is like proceeding under PP Act 1971. If it is a government land, LR 1966 regulation will go. PP Act will not apply.
So there is an application for condonation of delay. There is a
There is no
delay.
delay. But at an abandoned precaution, 30 days is a clear cut time. Not kindly see when the order was passed.
13.3 or 3.3.
3 I filed 3-4.
So why
As an abandoned precaution.
no, why haven't it?
I will not go with precaution. I'll show the statute. It's a 30 days, clear cut 30 days time.
So why you have filed this application? No.
I'll withdraw the
Yes.
section 5, I'll withdraw it.
So not pressed.
I will not kindly grant me leave motion.
Yes. The learned counsel for and how many can applications are there?
3 cases, 3 are separate can.
Oh, yes. So you are appearing on behalf of the respondent and you want to file affidavit in opposition. Stop. The learned counsel for the appellant has submitted that he wants to not press the application for condonation of delay since in fact there is no delay. What is the stamp reporter report? Stop. No. As there is no delay. Since in fact there is no delay. No delay. Delay in filing the appeal. Stop. The appellant is given liberty to do so. The petition application under section 5 of the Limitation Act. There is no delay. In spite of that, he had filed an application for condonation of delay. So not pressed. Being can number 1 of 2025. is dismissed as not pressed. Now, he has prayed for an interim order.
Can it be taken up tomorrow, Your Worship? Because I have not been served with the copy, I just got the copy.
I have no problem. Only one. The learned counsel for the, no, the learned counsel for the respondent has entered appearance. Stop. He prays for, sorry, she prays for an accommodation. Stop. This is the matter tomorrow, to be mentioned.
The
Same.
copy is served to me,
Oh,
today
oh,
itself, that
oh, no, okay, no problem.
it has to be recorded, Your Worship, because authority is
The learned counsel has also submitted that copy of the petition along with annexes has been served upon her today only. So tomorrow, to be mentioned,
Even the other matters, section 5 is there, that can be not.
same order. So in 3 matters you are appearing.
in the field.
Okay. So CR4. Just a minute. Mr. Kumar, CR4 and other 2 matters are item number.
It's one after another.
Oh, one after.
All the matters are fixed one after another.
Okay, please. CR4. Yes.
Yeah, my lord, I for the respondent state, his petitioner is a permanent resident of Gandhi Nagar village. I don't know, can you have a note of it? Gandhi Nagar village in Calcutta.
Gandhinagar village, Campbell.
In Calcutta.
Huh.
Now, my lord, you know, this Gandhi Nagar village is at 30 kilometers. It is also known as 30 kilometers.
Campbell. Huh.
It is also known as 30 kilometers.
Huh.
After this is Indira Point.
Indira Point.
Now they have initiated a case against me that I have entered into Indira Point, which is a restricted area.
Indira Point.
Which is a restricted area in terms of the notification.
It's a restricted area.
Yes. In terms of the notification of 2nd April 1957.
Number?
A notification dated 2nd of April 1957.
Huh.
Since it comes under the protection of Aboriginal tribes regulation. Now, my lord, first of all, my lord, this notification of 1957.
Hmm.
My lord, after this, presently, that particular village and particular area is inhabited by persons who are residing there. It is a village, it is a panchayat. So I am a permanent resident, born and brought up in that island, that particular village. And under no stretch of imagination, I am a resident of that person. I can be asked for any permit to visit this area. Now, my lord, they have initiated an FIR against me. My lord, may kindly see page number 28, the copy of the charge sheet.
But you are away from 30 kilometers. Your residence is away 30 kilometers away from the place where the.
No, after 30 kilometers only that Indira Point is there.
Why you have gone there?
Yes, my lord, it is there, my lord. A contract was allocated. I have enclosed that document also.
Contract.
Contract. A contract was allocated
By whom?
by the defense authority, my lord.
By defense authority.
Page number 12.
Is this a complaint case or?
No, page under 7 and 8. I will place 7 and 8 also, my lord. First of all,
Contract
that
was allocated by defense.
defense to one Fairmax, my lord, will get at page number 12.
Page number.
Page number 12 is the contract order sheet. My lord, may kindly see page number 12.
Yes, well.
Page number 12 onwards, my lord will find July 2019. MS Fairmax Trading Company, new number so and so will carry out the under mentioned work, supply and stocking of various construction materials brought from mainland stone boulder of so and so, stone chip so and so, for permanent work and RSB between 43 0.450 kilometer to 48.610 kilometer. My lord, may kindly have a note of this.
Yes, between this is not place, I think.
This is kilometer. My lord, that area is known as kilometer. I am residing in 30 kilometers.
Kilometers.
30 kilometer. Now, my lord, this is.
So this is 43.450 to 48,
Yes,
3 kilometers or something like that.
yes, 3 kilometer. Now, my lord, may kindly see the supply order also at page number 14.
Page number 14. So this essay was taken when? Essay or GR case, na? GR
Yes, yes.
Oh, sorry.
Now, my lord, this is the contract orders at page 14 and 15.
14 and 15.
15. 14, 15, 17. These all are those supply orders. My lord.
14.
Up to page number 20.
When you are apprehended?
I have been apprehended on 2021, my lord. FIR was February 2021.
So February 2021.
Yes.
2021. Oh, during COVID. 2021. You are apprehended.
Yes. Not
Yes.
apprehended. Never
Intercepted.
apprehended. Subsequently, they initiated a complaint, my lord, and thereafter I have been called to the police station.
So this is a complaint.
Complaint.
This is a complaint date. Date of complaint.
Date of complaint, my lord, I am giving the date of complaint is 18th of February 2021.
And what is the date of 2021?
18th February 2021.
21 and February 20 you have mentioned for which you have mentioned
My lord, I have this work order and all issued in 2020, 2021.
as 2021.
2020 is it is also there. Even after that also it was issued.
So when you entered that area, on which date you entered?
Their allegation, if my lord comes to 17th February 2021. Page number 35.
Page number 35.
My lord, second paragraph. If my lord sees this, it says दौरान तफ्तीश पाया गया कि दिनांक 17 मार्च 2021 को समय 5:30 बजे के आसपास मुलजिम स्वयं
So not 18 February.
No, my lord, how 18th February FIR was initiated, I don't know. Page 24. Page 22, my lord, we can see date of FIR. Page 22.
22.
Page 22. FIR, my lord, can you see?
Yes.
Page 22, my lord, we find FIR number 8 of 2021, dated 18th of February 2021. So, alleged incident, they allege that I entered into that land on 17th of March 2021, but FIR was 18th of February 2021.
Okay.
Now, my lord, the allegation, if my lord sees
35.
35. I'm just reading it out. It says कि दौरान तफ्तीश पाया गया कि दिनांक 17 मार्च 2021 के समय सुबह 5:30 के आसपास मुलजिम स्वयं जो कोस्ट गार्ड मेरीन कंस्ट्रक्शन एंड इंजीनियरिंग डिवीजन के एल&टी कंपनी में प्रोजेक्ट मैनेजर है ज्योग्राफिकल स्वयं इस प्रोजेक्ट के काम के सिलसिले में और सर्वे एरिया की शुरुआती जानकारी प्राप्त करने पर प्रोजेक्ट साइट इंदिरा पॉइंट के लिए रवाना हुए प्रोजेक्ट साइट दे हैव वेंट इन द प्रोजेक्ट साइट एट इंदिरा पॉइंट के लिए रवाना हुए उनके साथ के रुकेश्वर राव ईएस राजेश ही इज द पिटिशनर बिफोर माय लॉर्ड ईएस राजेश सन ऑफ लेट स्वयंसो गांधीनगर कैंपल बे तथा राजेंद्र राम स्वयंसो इंदिरा पॉइंट के लिए रवाना हुए उक्त चारों मुलजिम ने गलातिया रिवर बीआरओ ऑर्गेनाइजेशन जनरल रिजर्व के डोंगी से गलाती रिवर के पार किया नदी के दूसरे तरफ पहुंचकर दो बीआरओ वालों चारों मुलजिम एक ट्रक में 52 किलोमीटर में बीआरओ कैंप तक गए वहां से करीब 7:30 आवर्स को पैदल इंदिरा पॉइंट की ओर निकले करीब 11:50 में इंदिरा पॉइंट पहुंचे अपने प्रोजेक्ट के सर्वे एरिया लाइट हाउस और इंदिरा गांधी जी जो स्टैच्यू निरीक्षण किया बाद चारों मुलजिम शाम को 5 बजे के आसपास वापस कैंपल बे आए इस घटना चारों मुलजिम के दौरान अंडमान निकोबार एडमिनिस्ट्रेशन में कोई परमिट इंदिरा पॉइंट जाने के वजह से हुआ है. They have not taken any permit. This is what they want to say. Tribal Welfare Officer, Campbell Bay, Andaman Nicobar, notification dated 2nd April 1957.
So you have to show that even if you went there, so you can go there without permit. That is the point.
No, my contention is that
There is no requirement of
no requirement.
how you have to show us.
My lord, this is not in existence. We are residing there. If my lord may kindly see page number 22, page number 23.
You are residents of Campbell Bay,
I am resident of Gandhinagar, Campbell Bay. That is 30 kilometer.
30 kilometers.
30 kilometer.
Okay, 22.
Page number 23. My
23.
address is there.
Yes.
My name, my lord, will get at page 22, last line. C.S. Rajesh.
Yes, Rajesh.
And my lord will find that my address, Gandhinagar, Campbell Bay.
Yes.
So my contention is that, my lord, these aboriginal tribes are not residing anymore there. There is no aboriginal tribe at all. It is a panchayat where the people are residing. Now, my lord, can you see section 7 and 8 of the regulation which has been incorporated against us? My lord, can you see section 7 and 8? It is burden upon them to prove that it is a restricted area.
Page number.
No, my lord, that regulation.
Why is the regulation? You have given a copy.
Earlier, I have given this, my lord.
Hey, to me, yes. There is some regulation.
Yes. My lord,
Just a minute. There is office of the yes, tell us. Notification dated 2nd April 1957.
Yeah.
You are referring. That is the original order.
No, my lord, this is, my lord, can you see this book? I am just handing it over.
Okay.
This regulation at clause 7 and 8.
So 7 and 8.
This is the allegation against me. Eight subclause.
Extend to 1 year with fine.
Absolutely fine, my lord, but the thing is that when there is no law which prevents, because I am a resident of that area, why should I require a permit to visit my house and the nearby area?
Whoever in contravention of provisions sections, no person other than a member of an original tribe.
There is no original tribe at all.
So that regulation is still existing.
On the last occasion, my lord has asked, a query has been put to them and they were asked to produce this. And they have produced certain documents before this court, my lord. My lord, can you see those documents? This place is not there under the restricted area. That document on the last occasion they have placed. My lord, kindly have a look to that. Under the heading submission of report of amended provisions of that regulation, 1956.
Yes.
Now, my lord, can you see? The area has been clarified, which are the area where these regulations are applicable. Now, this nor Indra Point is there, nor Gandhinagar is there.
That is a report. Forwarding order dated such and such.
Submission of
Yes, as per the amendment notification number such and such. And the area located between coordinates mentioned below in eastern coast of Great Nicobar Island. In its east and
these areas are not there, my lord.
now for the remaining part of Great Nicobar Island, including Indira Point, falls under Andaman Nicobar Regulations 1956.
This they have written, my lord. They have enclosed the regulation. It is not there in the regulation.
Have you seen this? Last paragraph or something. Indira Point falls within this.
No, this is the report submitted by them. Along with this, they have the regulation. Regulation never says so. These are.
What is the regulation?
This is the regulation which they have imposed. Can you see, my lord? They can say anything, everything, my lord. This is a regulation, my lord. And that which my lord has read.
This.
Yes,
This is the 1957.
yes. And that what my lord has read, that is a letter written by the assistant commissioner in terms of an order of this court.
So according to him, this area does not fall within the restricted area.
In terms of the regulation, my lord, in terms of the notification, let them show from the notification.
Because the entry without pass is an
Offense.
violation of the section 7 of the regulation.
Now, according that the area is not within a restricted
At
area.
this stage, we are on for quashing of entire charge sheet and the affair regarding disputed locations, whether entry in the restricted area, purely matter of trial. Purely matter of trial. Lordship, kindly last part your lordship has read out that last portion exclusion, that is in the notification, that is 1957. That is Great Nicobar.
Hmm.
That is excluded. Moreover, Lordship, I applied tender work. I got for execution of the work. It is my duty to take a pass from the deputy commissioner. It doesn't mean that work was awarded to me without taking a permission from the competent authority. I have entered into the restricted area and executed work. 7 clearly speak without pass who are not a aboriginal tribe other than that person is a violation of
There
section
is no
7.
aboriginal tribe in that island.
But this regulation is still in existence.
Kindly see 7 and 8. 8 is the.
But there is no original
No
tribe.
aboriginal
Not
tribe there.
required, she, not required. Nowadays, not Indra point, it is declared by a notification because 7 speaks, kindly see. Lordship, the chief commissioner may by notification, it is time to time.
Where is the notification?
That is the notification
My lord, can you see
1957.
the order of this court whereby I asked them to produce the
1957.
notification? They failed to produce the
Lordship, kindly see
notification.
the last portion, your lordship already read out that part, that is report excluding.
Hmm.
Report excluding, that is in the notification.
Okay.
And moreover, lordship, entry on net entry, that is purely disputed questions of
There
right.
is no aboriginal tribe there. People are
Not
residing
required,
there.
not required. Nowadays, Carnicobar Islands, civilized people are residing. Even if I want to go there also, I have to take a pass from the report officer.
Okay.
That is
So
a mandatory.
and other two connected matters which
No,
I
this one,
so I shall have to this.
No, my lord, may kindly consider this aspect also. Earlier, this court has passed an order directing them to produce the notification, subsequent notification, if any, by which this was incorporated. Indra Point and Gandhi Nagar was incorporated. But they failed to produce the same. That, my lord, may kindly have a note of it.
This is the reply to our query you have submitted.
Yes. Yes. And
This report submitted by you was the reply to our query,
Yes, yes,
which has
yes,
been
yes.
referred.
that
to
time
by-
the amendment was not available.
এটা দিন তো ওনাকে।
My lord, that was in terms of an order dated 22nd of January 2024 by this court.
22nd January.
2024.
Lordship, I may be allowed to just say that.
Yes. You want to go through this?
Sir, I admit, that's.
We can take this. You obtained bail also, I think.
Available offense.
Yes.
But the offense is only 1,000 rupees maximum fine, my lord. But the thing is that I am a permanent resident of that place. It is not a restricted area. That side island is not a restricted area. No aboriginal tribes reside there. Only because in the year 1957 some regulation was there. The officers, for whatever reason, has unnecessarily arrayed me as an accused in this case. And my lord, kindly have a note of this on 22nd January 2024.
So what is your prayer right now?
To pause the entire proceeding, my lord.
For 482 CRPC or?
Yes, CRPC, ma'am. This was filed in 2023, ma'am.
You come to order number 22nd January 2024. On the basis of such order, this 11 June report has been submitted, and in that report, this has been referred that as per the amendment notification number 51 dated 20th April such and such is reproduced here in below. Then thereafter, all these comments or except of notification has been given. Sure. Now, their prima facie report is there, Mr. Kumar. This report, this report, it has been mentioned that which I have already shown to you.
No, my lord, this is the report submitted by Assistant Commissioner without any document. The document is contrary. The document which has been enclosed, it never says. Now, my lord, on the day when 22nd January the matter was taken, the court was about to quash this proceeding. My learned friend on the other day, my learned friend was not appearing. The earlier counsel on the ground that it might have been amended 6 times. Now, my lord, what they have done, they can write anything, everything, my lord. They enclose a document. That document never says that it is a restricted area. And I am submitting, my lord, that area is inhabited by the villagers.
Sir, how you have to prove it? You have prove it.
My lord, they
Show
have
us
to
how can
establish-
I
They have to establish, my lord, there exists a notification under which this area is a restricted
come
area.
tomorrow after getting some preparation? You please come tomorrow and submit. What can be done?
One notification that
Notification that is 1972 and the report furnished by the deputy commissioner.
You
is the
just-
proper authority.
You please go through the January 2nd and tally it, and thereafter you please. I find that the India point is there as per notification number
Notification 1972.
1972. Is there any amendment thereafter?
That was included, lordship.
Okay.
That was included during pendency of this matter.
So if you are ready, I can proceed. If you are ready,
Then tomorrow, lordship. I will
Okay.
clarify whether further amendment.
at the top. Okay, please keep it on top. The learned counsel for the the learned counsel for the petitioner has submitted that as per order dated January 22, 2024, comma,
Yeah.
the respondent, hey, list চলে গেছে. The respondent authority is unable to produce the relevant report. Stop. Para. The para, the learned counsel for the state seeks for an accommodation to come with better instruction. This the matter tomorrow. List বার করে দাও। Okay. Therefore, take a print out of the list. Print out বার করে। Okay, come tomorrow. Call the list.
Here, member.
Hmm.
This petitioner was charged for an offence under section 279 and 3048.
Hmm.
After full dress trial, he was convicted.
Convicted.
Actually, one person died. He was a bus driver. An accident taken place. In which certain injuries faced caused to some of the passengers, and one passenger died.
Yes.
The trial court convicted him.
Yes.
He preferred an appeal. Appeal court affirmed the order of conviction.
Yes.
Now, my lord, so far as the merits of the appeal is concerned, I don't want to argue. My contention, what I am arguing today, I intend to argue, my lord, that he is a first time offender And my lord, 304A very well comes within the ambit of Probation of Offenders Act and section 360 of CRPC. So if my lord sees the trial court and the appellate court has not at all considered this aspect of the case, my lord. If my lord comes to the judgment of the trial court,
The Probation of Offenders Act will come.
yes, definitely, ma'am. I will place judgments also.
Okay.
So my lord may kindly see.
So in the judgment, they did not consider this one?
They did not consider the very purpose of having section 304, section 4 of the Probation of Offender Act and section 360 of CRPC. My lord may kindly come to page 46. Inner page 27 of the judgment.
In page 27.
27 of the judgment. Appellate court has not considered. Trial court has written something which is not at all consideration, my lord.
27, yes.
27. Page 46, inner page 27.
Just a minute.
My lord, in my inner library.
Mohammad Rafiq Alam, GM. Yes,
Yes, my lord, running page 46.
yes, 47.
Yes, I want to find that the accused person so and so is hereby admitted guilty of the offence punishable under section so and so. Who is accordingly convicted under section so and so and liable to be undergo punishment for the same. Now this court is required to consider. What is that? Consider the applicability of the provisions of section 360 and 361 of CRPC read with section 4 of Probation of Offender Act 1958 to the convicted person. The convicted person is about 21 years of age. In the instant case, the accused person is convicted under section so and so, which attracts maximum punishment with imprisonment for a term of 2 years and fine. As such, this is a case where the court is required to consider the applicability of the provision of section 360, 361 CRPC with section 4 of Provisions of Offenders Act. The fact and circumstance of the case show a substantial degree of depravity on the part of the convicted person. It is not a case where the offence took place on some provocation or at the heat of the moment. It was voluntarily committed by the convict. The convict was driving the bus in a rash and negligence manner at high speed, knowing fully well that he was carrying passenger in the same whose lives and safety were in his hand. The passenger in the said bus had a right to be safely taken home, and it was the moral duty and or obligation of the accused person to drive the bus safely and drop the passenger to their destination. Safety. The passenger had not boarded the bus to risk their lives by either dying or sustaining injury. Such breach of duty by the convict could attract criminal punishment. Despite such moral duty and obligation, the convict breached the same by rash and negligence driving the said bus on so and so at high speed, resulting in accident of the bus and thereby caused the death of one of the passenger, namely Sangeeta Biswas, and causing of simple and grievous injury to the other passenger. It goes to show that the convict is not afraid of the law of the land. In these circumstances, I am of the opinion that convict on probation or conduct is unlikely to serve any purpose for his reformation, as the convict at present is a quite advanced and mature age. Moreover, dealing with the convict too lightly would seem a wrong signal to the society at large and would rather give the confidence to the wrongdoer. As such, now, my lord, this consideration is absolutely honest, my lord. The consideration, my lord, the Supreme Court has repeatedly said, my lord, when you are considering a person to be released on probation, you have to consider the financial status of that person, his society background, whether it's his antecedent. These are the considerations which ought to be considered to consider a case under section 4 of the Probation of Offenders Act. The consideration which has been made, that is the consideration for convicting a person for the offence, my lord. So therefore, this consideration which has been made by the court is no consideration at all to consider a case under section 4 and section 360 of CRPC. I will place the judgments on this court, my lord. Secondly, my lord, we find that in the My lord, may kindly come to the ordering portion at page 49.
Hmm.
Ordering portion.
Punishment for simply for 4 months.
Punishment is 1 year, my lord, altogether. But my lord will find in the next page.
Hmm. Ah,
Now, my lord, we find along with fine of rupees 1 lakh. My lord, under section 304, the fine amount of 1 lakh cannot be, madam. Maximum fine is, I think, 5,000 rupees. Madam. So these are the two part, my lord. First, the consideration for probation is not bad, and second, the punishment of the fine of 1 lakh that cannot be under section 304A of the Indian Penal Code, madam.
so he is now on bail.
He is on bail. Now, my lord, after this, we preferred an appeal. The appellate court has not even considered this probation, because we have argued this also
Hmm.
before the appellate court. Now, my lord, may kindly see. Now, my lord, page number 63, last paragraph. Page 63. Last paragraph.
Yes.
It says, law is a majestic edifice, sheltering each of us, each stone of which rests on the other. The conduct of the convict, though not a hardcore criminal, is not acceptable, and showing leniency would send a wrong message to the society, and resemblance needs to be thereafter one paragraph. Time is not there. My lord, releasing him in probation of misconduct would not serve any purpose, for his reformation of the act committed by him was voluntary, and it is only he who is to be blamed for the entire episode. So, my lord, this was the only consideration made by the appellate court so far as probation, applicability of probation of offenders act is concerned.
Hmm.
So, my lord, the appellate court has not at all considered and this probation of offenders act, and the trial court, though considered, but absolutely in the wrong line. Now, my lord, my contention is that this petitioner was aged about 35 years when the accident taken place. The trial continued for more than 10 years. My lord, this petitioner belongs to a weaker section of the society. He has his family and children, my lord. This ought to be the consideration which the court could have made while considering a case for release on probation, my lord. Now, my lord, I am placing the judgments on the said score, my lord, that this was the consideration which was not at all made by the trial court, my lord. My lord, this is 1981 judgment, my lord, we kindly see. Here said what would be the consideration, my lord.
Yes.
My lord, it says in this case, the question of dealing with the appellant under section 360 CRPC. What is
Hmm.
remains to be considered. For this purpose, we have directed that a report be called for from probation officer having jurisdiction. This report has been put in. His age, according to the jail doctor, was 24 years on 23rd of so and so, which means that on the date of offence, he was less than 21 years. The offence for which conviction has been rendered is one which will attract section 360 or at any rate the probation of offenders act 1958. The material before us are imperfect because the trial court has been functionary in discharging its sentencing function. We must emphasize that sentencing an accused person is a sensitive exercise of discretion and not a routine or mechanical prescription acting on hunch. The trial court should have collected material necessary to help award a just punishment in the circumstances. The social background and the personal factor of the crime doer are very relevant, although in practice, criminal court have hardly paid attention to the social or the personal circumstances of the offender. Even if section 360 CRPC is not attractive, it is the duty of the sentencing court to be activist enough to collect such fact as have a bearing on punishment with a rehabilitating slant. The absence of such material in the present case has left us with little assistance, even from the council. Indeed, member of the bar also do not pay sufficient attention to this legislative provisions which relate to dealing with an offender in such manner that he becomes a non-offender. He emphasizes this because the legislations which relate to amelioration in punishment have been regarded as minor act and therefore of little consequences. This is a totally wrong approach, and even if the bar does not help, the bench must fulfill the humanizing mission of sentencing implicit in such enactments as the Probation of Offender Act. In the present case, the offender is a young person and has antecedents have no blemish. His life is not unsettled or restless, and the report indicates that he is an agriculturist pursuing a peaceful vocation. His parents are alive and he has a wife and children to maintain. These are stabilizing factor in life. A long period of litigation and the little period of imprisonment suffered will surely serve as a deterrent. We are mindful of the fact that a firearm has been used by the appellant and we cannot slip over the gravity of the offense. Nevertheless, the report of the probation officer states that the appellant is not given to any bad habits or stress or poverty. A land dispute led to the crime and that does not survive any longer. The probation officer recommends that an opportunity be given to the appellant to improve himself and bring up his family by honor labor as an agriculturist so that the interest of social defense may be secured. We are inclined to agree with, in this case, the appellant may be given the benefit of Probation of Offenders Act. We are satisfied that the offender has a fixed place of abode and regular occupation. We are inclined also to rely upon the probation officer's report which support the direction for release of probation. We therefore direct the appellant be released on. My lord, this accused has used even arms. Despite of that, now my lord, why I show this judgment? What would be the consideration of the court while considering to release or not to release a person on probation? This is what this judgment says, my lord.
Now, in 304, I think that imprisonment and fine. In 304A, the punishment is prescribed imprisonment and fine. I cannot let him go only with fine.
No. Yes.
So we have to keep some period for his
No, but
imprisonment.
this is app on 304A.
Yes.
This judgment.
So it is completed now.
That judgment is, that is with regard to the preposition, what would be the consideration?
Yes, what is this?
This manner may kindly come to para 17. My lord. This here, which is a case where this is a case under section 304A. My lord, trial court and the appellate court, trial court.
So we have given two copies.
I am sorry, my lord.
So not a division bench. 17.
No, my lord, it is 2 years or fine, my lord.
2 years or
Or fine.
17. Huh?
Para 17, my lord. Yes. It says, my lord, the trial court convicted, appellate court affirmed, 304A, my lord. It says, reading the above case laws, one could understand that the provision of the Provision of Offenders Act should not be disregarded but should be followed, and an appropriate decision depends on the facts of the case be taken in each case. There was no absolute bar extending the benefit of section 4 of the Provision of Offenders Act to the convict who has been held guilty for the offence punishable under section 304 of the Indian Penal Code. The peculiar facts and circumstances of the case where that the petitioner has just completed 18 years, he was a teenager, and the excitement and happiness he might have driven the new vehicle for the first time and lost control. In the ordinary course, he had no reason to take the vehicle away from the road and cause an accident. His age and the way in which the accident happened are the peculiar facts to be considered in this case. He has a bright future. He is apprehensive about the stigma of conviction that may ruin his future. The mens rea is absent in such case. He was the first time offender and had no antecedent. Therefore, without disregarding the probation of offender act, this court is of the view that in the facts and circumstances of the case, it is expedient to release him on probation under section 4 of the probation of offenders act. And thereafter, how it will be released and what the probation officer will do. Here, my lord, admittedly, I was a driver in a bus. I was driving that bus for years together. The court said he out of his own, he has done this. My lord, I was driving that bus for years together. And it is an accident. 279 clearly says, my lord. It's an accident. It is not that I deliberately went and hit. And because of that, this accident has been taken place.
The court has to consider the victim's fate also.
Absolutely, my lord. Absolutely.
One person died.
Yes. My lord,
That has to-
304 a person died, my lord. That's
It is true, but the person does not know that he will not come back to his house.
my lord. Definitely, my lord. And it was an
Nobody
accident.
knows.
Nobody knows. My lord, it was not a
When I am proceeding, I do not know whether I shall be able to go back to my home. Then,
It is not a deliberate, my lord. What
no, that is true. That is true. But what a magistrate can do? He has given a minimum, I think, 1 year.
But my lord, I am not on punishment. I say
Yes, you have said that the personal factors.
they are not taken into
But
account
okay,
first of
now,
all.
then what is your suggestion? You are not challenging the conviction. You are
I am
not.
not challenging it.
You are only that the process of sentencing him is not properly considered. That is
Not
your
properly considered with regard to the provisions
Personal
of
factors.
probation of-
yes, personal factors that he
Now,
has.
this court can very well consider it.
No, I have to hear it. It has to be heard by the concerned court. If I allow your prayer, okay. Let us hear
No,
Mr.
my lord, I am relying on-
Another
Yes, some judgments, my lord, because
first time experience. I have seen in my case what happened. A boy of 18 years or 17 years came out with his father's car and dashed against my car. So you are saying that is a excitement, young age.
my lord,
Then-
that is the judgment of this
That
court.
is a judgment. Say son of a rich millionaire, he came with this car, and in the happiness, in the excitement, he caused it. Whatever it may be. No, please.
Now, my lord, may kindly see para 4 and 5, my lord. Here, the conviction was under section 323, 325, 148 and 149 of the Indian Penal Code.
Yes.
Now, my lord, here the court has taken into account that the trial prolonged for a period of 11 years. Now, my lord, may kindly come to paragraph 4 and 5. my lord. It says, when the case came up for admission before this court, the learned counsel for the appellant raised the contention that the provisions of section 360 CRPC have not at all been looked into, and we therefore issued limited notice as to why the said provision will not be attracted to the facts and circumstances of the present case. The provisions of section 360 CRPC are beneficial to the accused only when the accused is a first-time offender in case the accused is more than 21 years of age. Section 361 of Code of Criminal Procedure indicate that if the court decides that not to exercise its jurisdiction under section 360, then it must record its reason as to why the benefit under section 360 CRPC is being denied. In view of peremptory nature of language of provision of section 360, magistrate as well as the court in appeal and revision, not having indicated as to why provision of have not been applied, there has been a gross miscarriage of justice, and the legislative mandate engrafted in the aforesaid 2 section of the code have not been complied with. In these circumstances, after hearing the learned counsel for the appellant and so, bearing in mind the facts and circumstances, we are of the considered opinion that this is a fit case where the court should have invoked the provision of section 360 CRPC, while therefore upholding the conviction of the appellant instead of sentencing him with direct, they shall execute a bond with money surety to the extent of 10,000 for a period of 1 year, which here they shall continue to be on probation for good behavior and keeping peace. Now, my lord, here, both the court has convicted me. Now, my lord, the Supreme Court, my lord, the Supreme Court released me on probation, man, for a period of 1 year.
How long you are in custody initially?
It's a payable offense.
304A.
Yes. Payable offense.
So. So there is no. Okay.
But here the case was under section 302, my lord. Subsequently, my lord, he was convicted under section 304, part 2, my lord. Para 2, my lord. There are two paragraphs, my lord, can you see? It says this appeal is directed against accused number 3 alone who has been convicted by the court under section, but on appeal, the High Court set aside the conviction under section 302 IPC and instead convicted him under section 304, part 2. For such conviction, the High Court also examined the circumstance under which blow was inflicted by the accused and the deceased on consideration of the provision of section 360 CRPC read with section 4 of provision of Act, and the High Court instead of sentencing him direct to release the accused on admonition. The learned counsel for the appellant is not in a position to assail the acquittal of the accused under section, but eventually contended that the court did not bear in mind German consideration for releasing the accused on probation after convicting him under section 304 part 2. Whether the benefit of probation could be extended in any particular case depend upon the circumstance of that case. Admittedly, there is no statutory bar for application of the act to an offence under section 304 part 2, where the maximum punishment is neither death nor imprisonment for life. In that view of the matter and on examining the impugned judgment and the High Court, we find that the court had considered the relevant material and then come to the conclusion that the accused should be released on probation by applying. Now, my lord, may kindly visualize the situation. 304. My lord, a person, for whatever act, a person died, man. But the court, considering that this is a case under 304 part 2, exercising the power, the court has released him on probation.
Okay, we have to consider the manner of the accident, how the
No, my
accident
lord,
has taken place.
first, my lord has to consider that the trial court and the appellate court both have not considered this.
The manner of accident or the probation.
Accident, my lord,
Probation. Probation.
my lord, the merits of the
But
matter.
360, section 360 has been considered by the trial court.
No, trial court has considered altogether different aspect. The trial court considered the merit of the case.
Yes.
The trial court could have considered the antecedent of the accused, what was his family
Family
background,
background,
this all consideration was there. That is what Justice Krishna Iyer said in
Yes.
his 1981 judgment.
So what is Mr. Pavakar's submission? I think you have finished. Sir, you have finished.
My lord, even my lord, in a case where 376 read with section 511, he was given the benefit of probation of offenders act and he was released.
Which court?
Supreme Court. Paragraph number 2. Paragraph.
What is the age? What is the age of the victim at that time? The 376, 511.
11. Yes, 376.
Attempt.
Attempt.
Not, I thought that even 376, I think it will not
What I
apply.
am on, my lord, there are two parts of my argument.
Yes.
First, I say that it was never considered.
Yes,
And I am
yes.
before my lord, may kindly consider this aspect. I was before the trial court for more than 11 years. Now, my lord, this accident has been taking place 30 to 40 years ago.
13 to 14.
2014, my lord.
Oh,
2014.
yes, Mr. Komoga.
See,
Only small
Regarding
point.
provision, I am not going to the merit of.
Yeah, only provision. Now, probation has also been considered. 360 has been considered, but the angle is different.
360 and section 4 of the Provision Act is not a mandate. It is a totally discretionary of the trial court as well as the first argument. And first trial court has categorically discussed about 360, why he have been sentenced and why he was convicted. It is observed, suppose lordship, in trial court, the trial court did not touch or observed in connection of section 360 of CRPC, then lordship can interfere with the order that regarding 360, if it is applicable for the offence under section 304A IPC, that can be considered by the first appellate court as well as by this honorable High Court. But in the trial court, they specifically stated, because the mode of the nature, how the accident taken place, that also has to be seen. It is not like that 304 accident, one person have been died. He was driving a passenger vehicle. He should be more cautious than us when I was driving my personal car. Because passengers were sitting in the bus.
Well, in the passage, the person died is a passenger, was a passenger or
Not she,
passerby.
Sangeeta, victim, deceased, she was a passenger. She was a student. It was a passenger bus. And this petitioner was driving that passenger bus. Now regarding rash or negligent driving, lordship, I have to more cautious than other driver because I am carrying a passenger to reaching the destination. More cautious has to be taken by the passenger driver. So 360, 4 of provision that is observed by the trial court and as well as the first appellate court also.
In that discussion, he did not concentrate on his family background or any other circumstances, social factors.
Lordship, I already argued, lordship, regarding that is 360, that is not a mandate that it has to be given. It is a totally discretionary. If there was a no whisper about 360 by the
Okay.
trial court as well,
রেখে দাও আর অন্য এগুলো
it
দেখি।
would have been understood, lordship. I also, lordship, there was the accident, lordship.
The learned counsel for the petition appellant or revisionist, no? Revisionist has concluded his submission. Stop. He has referred several case laws and judicial decisions to point out that the learned trial court and the first appellate court did not consider the provisions of Probation of Offenders Act in right with proper perspectives, since they did not consider the family background, social factors attached with the convict. Stop. Para. The learned counsel for the state opposes the above submission of the learned counsel of the revisionist. Stop. According to him, application of section 360 CRPC or Probation of Offenders Act at the time of sentencing a convict for commission of offense punishable under section 304A is not mandatory. Stop. Both the learned counsels have concluded their submission. Let the matter fixed or notary 10th for orders.
Only one thing from the learned friend said, submitted, it is not mandatory that judgment of 90.
See, I have recorded his submission on that.
We have made that submission.
It's not mandatory. According to him, it is not mandatory. That has been recorded. এটা আজ এখনই পাঠিয়ে দিন তো ওখানে ভালো করে করে দিন। হ্যাঁ, নেক্সট।
Not I am appearing for opposition. And for the private respondent, the company and the court of assistance.
And for the states.
Yes. What happened?
Here. Not here. The 4 persons have initiated a complaint against the respondent number 2,
BM Kumar.
BM Kumar.
What is his designation?
He is the assistant sub inspector of police.
GM Kumar.
So my lord, 4 individuals made complaint against the respondent number 2 before the police station for committing offence.
4 complainants.
4 complainants, 4 different complaints were initiated
Complained against whom?
against the respondent number 2, the complainant before the trial court,
Gopesh Vishwas.
Rupesh Biswas, for committing the offence of forgery and cheating.
Yes.
Police did not take any action. They took out an application under section 156(3) before the CJM court, Chief Judicial Magistrate. Chief Judicial Magistrate directed the police authority to conduct a preliminary inquiry as to whether the offence is constituted or not, and to submit a report. This petitioner, who is before my lord, was assigned with the duties to conduct the preliminary inquiry. He conducted the preliminary inquiry and submitted a report before the court of Chief Judicial Magistrate, whereby he held that the case is made out.
That's true.
On the basis of his preliminary inquiry report, the Chief Judicial Magistrate directed for initiation of an for FIR against the respondent number 2.
Yes.
On the basis of such direction issued by the Chief Judicial Magistrate, 4 FIR was issued. 4 FIR was registered under section 465, 468, 471, and 420 of the Indian Penal Code against the respondent number 2.
Charge sheet submitted.
Initially, my lord, FIR was registered. After registration of the FIR, initially in 2 cases, I was made the investigating officer. Subsequently, other 2 cases were also handed over to me, and I have filed charge sheet in all the 4 cases. Once, my lord, this FIR was initiated and charge sheet was filed, my lord, this respondent number 2 started interfering with those 4 complainants by using criminal force. As a consequence of which, necessary complaints were made by the Pradhan of that area. Even when the law and order problem was there, the Tahsildar has made a complaint, and on the basis of that, when he was on duty, he attended the said field on 20th of February and 21st of February 2023. 20th of February and 21st of February 2020.
21st.
20th of February 2023 and 21st of February 2023. Now, my lord, when he attended, there was law and order problem, my lord, and when he was trying to resolve the issue, my lord, this respondent number 2 threatened him with dire consequences to this petitioner, and to which the petitioner has initiated an NCFIR in the police station against the respondent number 2. When, my lord, the petitioner was sent on duty to look after the affairs there, to have control over the law and order, my lord, he used criminal force and threatened this petitioner. As a consequence of which, the petitioner also initiated an NCFIR against him in the police station. Ultimately, it converted into challan. When the law and order problem was there on 20 and 21st, my lord, those 4 de facto complainants initiated FIR against this respondent number 2. And this respondent number 2 initiated FIR against them. That those 4 de facto complainants.
4 complainants.
4 complainants, because the issue was between them. Those 4 complainants initiated a complaint in the police station against the respondent number 2, as a consequence of which an NCFIR was initiated against him. And he also initiated NCFIR against all those 4 persons. And in the said NCFIR, he specifically stated that police has interfered and they have saved me.
Yes.
So, my lord, no NCFIR, no complaint was initiated against me by him. Though I have initiated an NCFIR against him, rather he said, police has saved me. I can show from the NCFIR. Now, my lord, subsequently what he done, he filed this complaint case against those 4 persons.
Hmm.
He arraigned the Pradhan and the all other officers, all other persons, including this petitioner.
Hmm.
While filing this complaint case before the court, he suppressed and in one paragraph, he categorically said that no case is pending against me before any court of law.
Hmm.
He suppressed the entire episode
In his complaint.
in his complaint. And he made a specific amendment saying that no case is pending against me before any court of law. Immediately after filing this complaint case before the magistrate court, my lord, he initiated a complaint before the Director General of Police against me,
Against you,
against the petitioner.
Director General of Police.
Director, because I am a police person,
So intimated the,
he not intimated, he made a complaint saying that he has committed a heinous offense. You conduct an investigation against him.
huh,
On the basis of the said complaint, police DGP directed the police authority to conduct an inquiry.
Hmm.
An inquiry was conducted.
hmm,
And in the inquiry, my lord, the police authority came to a definite finding that all the facts were wrongly placed and it is a frivolous complaint made against the petitioner. That report is there.
hmm. Yes.
Now, my lord, my first contention is, my lord, that by suppressing the material fact of initiation of 4 complaints against him and which culminated into 4 charge sheets for an offence under forgery and cheating, he filed this complaint case. Suppression of-
Or is the suppression that there is no case pending
Yes,
is this with a page?
yes,
number?
yes. Para 10, page 43.
Yes.
That there is no complaint pending against the complainant in the police station.
Yes.
This is the suppression of facts.
Hmm.
Now, my lord, this fact has been suppressed. Now, my lord, I am a government servant. At no point of time there was any allegation against me. This allegation, what allegation he has made, that is contrary to the finding of the authority, the police authority on the basis of his complaint.
Hmm.
Now, my lord, sanction under section 197 is mandatory to initiate a complaint against the government servant.
Hmm.
My lord, on 3rd of April 2025, the Honorable Supreme Court has passed an order whereby the Supreme Court said, if a government servant, while discharging his duties, exceed the duties, then also sanction is mandatory.
Hmm.
Then also sanction is mandatory. Here altogether suppression of material fact. Now, my lord, may kindly see.
And another thing, you please, the inquiry report, have you
Yes.
submitted inquiry report?
Yes, my lord.
That you are, all factual aspects are false?
Yes, yes, my lord.
Where?
First, my lord, may kindly see the complaint addressed to page 54. His intention is very clear from the complaint. Page 54. My lord has seen the address, my lord, Director General of Police, Superintendent of Police.
Hmm.
Intimation with regard to taking cognizance of criminal case against D.M. Kumar, Assistant Sub Inspector of Police, presently posted at so and so, under section so and so, so and so. My lord, may kindly see paragraph number 3. The offence committed by whom is heinous against the norms and dignity of police fraternity and society at large. Got it, my lord? Now, my lord, can you see the report of the police, my lord, page 51, 57, my lord.
Yes.
This I have obtained under Right to Information Act. Office of the Superintendent has supplied it. Now, my lord, can you see? And contents in the complaint and the complaint case are entirely different, my lord. My lord, can you see page 58? It says, my lord, gist of the complaint. Got it? It says in the aforesaid complaint, the complainant Gopas Biswas has alleged that he has instituted a civil suit number so and so, right, or directed the defendants to maintain status quo over the suit property till disposal of the suit. However, ASI DM Kumar had been to the said suit property specifically on 20th February 2023 and 21st February 2023. My lord, can you have a note of it? In his complaint, the allegation is altogether different. 20 and 21 and question some irrelevant things. It is specifically alleged that ASI VM Kumar has committed criminal trespass into the suit property in survey number so and instigate the local politician and resident of so to form unlawful assembly and to commit riot upon the complainant with deadly weapon with dao, rod, lathi, etc. and the further causes injury to him. He has also alleged 2 separate complaints and 7 complaints of SHO did not take any action against the complainant ASI Kumar. Material facts on record. Thereafter, it has recorded, my lord, these are the materials which were placed. Now, my lord, we kindly see page 60, second paragraph onwards, the date of incident. What the police authority says. That on 20th of February 2023, got it, my lord? At about 17 hours, a telephonic information was received at police station Afrigan from Tahsildar Fararganj that above Gopes Biswas has done some illegal construction in the aforesaid government revenue land at Ahmedabad and hence to stop at once on the basis of the above information received from Gopal Kumar Tahsildar Fararganj, ASI DM Kumar and Head Constable 1682 Amal Kumar Das of Police Station Afriganj, who were deployed as day duty staff, has proceeded to the above landed property and instructed the laborers and caretaker of Bhakti of Gopes Biswas to stop the construction work and to meet the Tahsildar Fararganj in the matter. Copy of GD entry number so and so, video clip so and so. So, my lord, GD entry, everything was made in the police station. This is the incident pertaining to 20th of February 2023, my lord. Thereafter, my lord, on 21st of February 2023, at about 11:20 hours, undersigned conveyed a telephonic information at police station African that some persons have been removing fencing of encroached revenue land of above accused Gopes Biswas. On the basis of that, ASI so and Amal Kumar Das, CC 655 of police station Africans who were deployed as day duty staff has been proceeded to the above landed property and found that a person namely Nitya Kumar Ghosh.
So what is the conclusion? The above material facts available on record ipso facto provides that the instant complainant Gopes Biswas has originated the above complaint with all of its mala fide intention.
Yes.
That is the
There is
conclusion.
no iota of truth.
That is the conclusion.
Yes, there is no iota of truth in the instant complaint, appropriate action. Now, my lord will find that this complaint was made by him after filing the complaint case before the court of law. Now, what was his intention? He firstly filed a complaint case. Thereafter, my lord, he makes complaint before the higher authority. He thought that higher authority will take whatever action because he has not done anything wrong. Therefore, the higher authority comes to a definite finding that it's a frivolous complaint made by him.
Okay.
Now, on the set score, my lord, the complaint case was filed by him.
So you want what? What is your prayer?
Washing of the proceeding, my
Washing
lord,
of the
that
proceeding.
cannot be
So I
against me, my lord.
have to hear Mr. Kormokar. Yes.
Lordship Parliament, it is between complaint case, first private respondent.
Oh, yes, no
No,
problem.
my lord, I am relying upon judgments, my lord, on 197 and suppression of material facts before this.
Be quick, be quick. Now, if you want to read every,
No,
then
my lord,
it will cause problem. Okay.
Please.
Please show us the relevant judicial decisions. 197 sanction order.
Sanction, my lord, I will give. Sanction latest judgment also I will provide.
Okay.
I am sorry, my lord, I have 1 second, I have given 2 copies. My lord, suppression of material facts, my lord.
Yes.
Para 13 onwards. My lord, may kindly come to page number 7, inner page 7.
Yes.
Thus, in view of the aforesaid, it is clear that the respondent, while approaching the judicial magistrate first class by filing a complaint under section so and so, has suppressed the material fact that the police has already conducted a detailed inquiry and submitted its report. On the contrary, the complainant has made a false statement in the affidavit. The police has not done anything on the complaint, and therefore the victim has no other alternative for him but to approach the court.
Hmm.
It clearly indicates that the direction given by the magistrate without application of might. If the inquiry report would have been submitted before the magistrate, you would have taken a different decision, and it was possible that the complaint would not have been entertained. Now, my lord, if the court would have been enlightened about the tendency of the 4 criminal case against him, the court could not have, and this petitioner was the investigating officer in all the 4 cases. The court could not have, my lord, suppressing the material facts before the court, my lord. The court pursued on what all material he has placed before the court. And he has given an undertaking saying that there is no criminal case pending against me.
Hmm.
Now, my lord, in my complaint, my lord, I have enclosed the FIR and
Everything.
copy of everything is there. Thereafter, it says it is expected that from a litigant to approach the court with a bona fide and without any ill motive. The judicial forum are not available for harassing the person, but it is available to protect the right of the parties. And therefore, it is expected that all the correct facts should be placed before the court. In my opinion, the complainant respondent number 2 in the existing circum was not entitled to get any order from the court because he has suppressed the very material information from the court that police has conducted a detailed inquiry in which it was found that the incident of so and so, so and so. Thereafter, my lord, it was para 16, it was quashed, my lord.
Okay.
Considering upon the decision, upon hearing so and so, is allowed. The impugned order dated so and so is set aside. Consider the impugned complaint case is also quashed. However, there will be no order to quash. Now, my lord, this is with regard to suppression of material fact. Now, my lord, this is with regard to 197. Page 24 onwards, my lord.
24.
Page 22 onwards, my lord.
Yes.
It says, my lord, he wrote page 22. My lord.
Yes.
Says the law relating to the requirement of sanction to entertain and to take cognizance of an offence allegedly committed by a police officer under section 197 of Code of Criminal Procedure, which section so and so is well settled by this court, inter alia by its decision referred to above. Sanction of the government to prosecute a police officer for any act related to the discharge of an official duty is imperative to protect the police officer from facing harassing, regulatory, revengeful, and frivolous proceedings. The requirement of sanction from the government to give an upright police officer the confidence to discharge his official duties efficiently without fear of vindictive relation by initiating of criminal action, from which he would be protected under section 197 of the Code of Criminal Procedure with section 170 of their. Every offence committed by a police officer does not attract section 197 CRPC, read with so and so. The protection given under section 197 of the Code of Criminal Procedure which also has its limitation. The protection is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty, and official duty is not merely a clock for the objectionable act. An offence committed entirely outside the scope. It is not an outside the scope. Thereafter, paragraph 68 says, if in doing an official duty, a policeman has acted in excess of duty, but there is a reasonable connection between the act and the performance of this official duty, the fact that the act alleged is in excess of duty will not be a ground enough to deprive the policeman of the protection of the government sanction for initiation of criminal action against him. So on this score, my lord, the court held that 197 is mandatory. Now, my lord, this is the latest judgment, my lord, of 3rd April.
Yes.
Paragraph page number 19, para 30 onwards.
Yes.
A careful reading of section 197 of CRPC unequally eliminates a statutory bar on the court's jurisdiction to take cognizance of an offence alleged against public servant, save without the prior sanction of the appropriate government. The essential precondition for the applicability of this provision is that the alleged offence must have been committed by a public servant while acting in the discharge of or purported discharge of their official duty. The protection mentioned of section 197 of the CRPC, however, is not absolute. It does not extend to acts that are manifestly beyond the scope of official duty or wholly unconnected thereto. Acts verity of any reasonable nexus to function to official functions falls outside the ambit of this safeguard and do not attract the bar under section 197. Both the aforesaid provision serve a similar protection function. Thereafter, my lord, the court has relied upon several judgments
Okay,
and
sir.
arrived to a definite finding, my lord. If my lord comes to page number 30, my lord. Page 42 is the operative portion, my lord. 39. Para 41 says, admittedly, the alleged incident pertaining to the period so and so, the proceeding now survives solely against accused number so and so. It is pertinent to note that both the
No,
accused
no, not
persons
really.
retired from service long on attaining the age so and so. In this circumstance, of the circumstance that no meaningful purpose would be served by prolonging the criminal. Accordingly, we are satisfied that the end of justice would be adequate met in the instant case by quashing the proceeding against the accused number 2 and 5. And therefore, the proceeding was here, my lord. The allegation was that they took the accused, the respondent, to the police station and they have assaulted in custody. That was the allegation.
Okay. Anything else?
My lord, abuse of process of law, my lord, I'll say. This, I am referring one judgment, my lord. My lord, may kindly see. Para 12 to 14 onwards. my lord.
Abuse.
This is, yes, abuse of process of law, my lord. Para 12 onwards.
Para?
Para 12 to 14, my lord.
Yes.
It says, my lord, though it's arising out of civil case, but the court observed that unnecessarily. My lord, can you see this case indicates that a blatant abuse of the process of the court. The petitioner not only took the benefit of an order of the High Court granting them 1 year time to vacate the but obtained a further extension of period of so and so. The petitioner then filed a review petition before the High Court and moved another application. The time of the High Court and the unfortunately of this court as well as had to be devoted to thorough frivolous proceedings. Then at counsel for the petitioner in fact sought to urge that as a result of the judgment of so and so, the petitioner has been deprived the establish that their status, license, infrastructure. My lord, can you see para 13, my lord? This court must view with disfavor any attempt by a litigant to abuse the process. The sanctity of the judicial process to be seriously eroded if such attempts are not dealt with firmly. A litigant who takes liberty with the truth or with the procedure of the court should be left in no doubt about the consequences to follow. Others should not venture along with the same path in the hope or on a misplaced expectation of judicial leniency. Exemplary costs are inevitable and even necessary in order to ensure that in litigation, as in the law which is practiced in our country, there is no premium on the truth. Court across the legal system, this court not being an exception or charged with litigation. Frivolous and groundless filing constitute a serious menace to the administration of justice. This consume time and clog the infrastructures, protective resources which should be deployed in the handling of genuine cases as genuine cases, my lord, are dissipated in attending to cases filed only to benefit from delay by prolonged dead issues and personal workful process. So, my lord, by citing this, I say this is abuse of process of law, my lord. Furthermore, my lord, I am a police person. I have been governed under the Andaman Nicobar Police Manual, my lord. Under the manual also, chapter 10 says, if you intend to initiate any process, you have to take concurrence of the Inspector General of Police. At that point of time, it was not Director General of Police, Inspector General of Police. So, my lord, without the concurrence, without the sanction of the authority, if you intend that I have done something which is wrong, you could have applied before the authority saying that I want to prosecute him. You give me sanction. If they are not giving sanction, then the question of being sanction will come or not that's altogether different aspect. You and my lord may kindly have a note of it. When the NCFIR was initiated, he says that the police persons have saved me. I was the police person who went there along with 2 others. It is there, my lord, I have enclosed
Yeah,
it.
yes, I have seen.
So he says that we have, because of us only he was saved. And subsequently, without any NCFIR, nothing against me, he straight away initiated complaint against those in terms of the NCFIR initiated by him and incorporated my name. So my lord, I say it's an abuse of process of law, suppressing the material fact before this honorable court without obtaining any sanction from the authority, my lord, it ought to be cautioned.
Take, that's all. Yes,
My lord, first of all, may I-
you are Gopesh বিশ্বাস, you are Gopesh, you are
You come.
respondent number 2.
Just one number. First of all, Lordship, kindly have a look page 57. The report prepared by the police on the basis of my complaint made to the higher authority, hierarchy of the police.
57, page number.
57. So this is the proceeding initiated. No opportunity was given. It is ex parte bias and even till that no copy was struck. It is not binding. Since I am not a party to that process,
Yes.
it is totally ex parte and bias. Lordship knows that a criminal law set in motion. Lordship,
Yes,
a criminal law set in motion when there is an information by any person to the police. And police can set the criminal law in motion only after reducing to writing that information if it is a cognizable offense. As per section 150. Lordship, if it is a non-cognizable, then 155. In case there is any urgency, Lordship, at least DB entry is required to admit to the spot. To maintain the law and institution. Lordship, kindly have a look. Their petition, page 5. Page 5, Lordship, paragraph 8. I am reading, Lordship. Under what authority this police person has been to the spot and to form an unlawful assembly and causes them to and instigate them to cause riot. Lordship, can a police officer can go in any place where an incident is occurring without reducing to writing any information, without any authority? This is the question, no question in the matter. I am reading, Lordship. Paragraph 8, page 5. Your petitioner states that on 20th February 2023, a telephonic information received from the police station from the Tahsildar Pragnat regarding illegal construction in the government land at Hasmatabad by the private respondent directed to establish an address. Lordship, then 3 paragraph I am reading. Your petitioner states that on the basis of such verbal information by the Tahsildar Pragnat, the petitioner who was deployed as the duty staff along with AC Head Constable Itna Amal Kumar Das in the police station African proceeded to the site disputed land on 20th to 2023 and instructed the labor and caretaker of the private respondent in the Bapi to stop the construction work and to meet the Tahsildar Pragnat. This is one aspect, Lordship, on the basis of an information from the Tahsildar. Lordship, whether that information is reduced into writing by the police in the police station, there is no whisper. There is no FIR, no GB entry, nothing. Moreover, he admitting that he had been to the spot. Lordship, next paragraph 10, Lordship. Your petitioner stated that on 21st February 2023, again, the station house officer who had telephone informed at police station applicant that some person are removing fencing of encroached government revenue land of the private respondent Gopesh বিশ্বাস, the petitioner who was deployed as duty staff on 21st February 2023 at police station, applicant was directed and he proceeded to the site disputed land and found that some person are taking water from the pond located in the disputed land of private respondent and they are removing the illegal fencing made. It is their statement. On the basis of an information from the SHO, this duty officer is claiming that he had been to the spot where this wall is unlawful assembly and riot is going on without any reduction to right. Now, what is the Lordship? I will bring your Lordship kind attention. What is the case actually? This private
being
Okay.
SHO or being a police officer. At that relevant point of time, 197 sanction is required. I am arguing here, Lordship, I slapped somebody. Whether sanction required or not, answer will be definitely not. It is different part, it is not my duty.
So it is also not required for, in this case.
197 not recorded, as
Why,
per my
why,
little knowledge.
why,
Lordship.
why not? Everybody has little knowledge.
Lordship, as per my.
Everybody has little knowledge. So, so in this case, he is not in discharge of his official duty.
Lordship, entering, his duty was not slapping, threatening, assaulting, that was not in under the duty. That is not, I being a police officer or being any
That is
officer.
the law. If he is not in his official
Lordship,
duty,
any officer.
no, any act which is not in discharge of his official duty,
197 not
197 will not.
required.
That is the only
I
submission.
wear my wearing, I wear my uniform.
That is the only submission, I think.
Sometimes catch somebody. That is not 197 not required. So regarding cognition, Lordship, it is just a notice, judicial notice to the court. What is the next stage? Someone will be issued. Then bail has to be granted. Thereafter, plea or charge will be taken. In non-cognizable offence, plea will be taken, read over. In cognizable offence, charge will be taken. If there is no evidence at all, then immediately should be discharged.
The learned counsels for the parties have concluded their submission so far as the কিসের জন্য ছিল আজ এটা? Why? What reply? Every what judgments? You have given at least 5 judgments. In spite of that, not required. He will give you.
Even the public servant has exceeded his duty. Then.
He has already given. He has already given. Your senior has given. You are exceeding your jurisdiction now. What is have submitted? Have concluded their submission. Stop. Let the matter be fixed for order. 10 তারিখ 10 তারিখ। হ্যাঁ, ঠিক আছে। Next level, next level. It is office চলে যায়। Okay, next এখন
Fine, you are 22 or 25.
9.
Okay, one of 25.
Can not apply for the petitioner. Anticipatory bail.
Who is for
For
the
the state Lordship.
yes? Tell me
Lordship, case day will required. First date it is coming.
why?
Case day required, Lordship. Anticipatory bail. Allegation 302.
So come back tomorrow.
Lordship.
Tomorrow. The learned counsel for the state has submitted that CD is not available. He seeks for an accommodation. This is the matter tomorrow.
Okay.
Now you are 86 or 25.
Yes, what happened? Huh?
What should I say?
Not today, not today.
Yeah, now you are 90 or 25. Well, I'm for the storage.
So which for the petitioner? No. Yes,
But for a very short pass over.
then not today.
Not today.
Next,
Same thing.
not today, not today.
In 14, the 16,
Right. Amit Kumar Vishwas. No, not today.
You're talking about 2025.
In spite of my best efforts, the opposite party number two could not be served.
Oh.
First, I made an attempt to should show that insufficient address to the next set. I'm enjoying.
The learned counsel for the petitioner has prayed for placing the matter in the next circuit since service upon the respondent number two is incomplete.
Alright, I am agreeing with the petitioner.
Now for respondent number 3 and 4.
And respondent number,
The matter was excellent study because of the regulatory. Certain counsel for the respondent of 1 and 2 was not taken.
so they are the answering respondents.
No,
They are,
I have applied for grant of electric connection for agricultural purpose.
yes,
And the authority concerned, the respondent 1 and 2 asked for the no objections from the court enemy. The private respondents are the court enemy. We
yes.
have a private dispute, personal, family dispute. So they are unable to, they are not going, giving the no objection to me.
The Srimati Videshi Rai and,
Not seeing this.
oh, sorry, Sri Videshi Rai,
Sumangol.
Sumangol Rai.
Videshi Rai, my father, and Sumangol is my brother. And there is the will executed, registered will executed by my grandfather in favor of me, my father, and my brother.
Whether the service upon 1 and 2 is
Yes,
complete.
First occasion, the counsel appeared.
So who is usually
Mr. Satish Kumar Misra. Mr. Satish Misra is the standing counsel. for me.
request him to come?
First occasion he appeared, he said, "No, if necessary, I will file opposition." They are the private respondent, can't do it.
So, okay, we can proceed then, yes. You can, why you are objecting?
I was objecting because the said land where the petitioner is in possession, he's declaring it, but he is not in possession. He is in possession in survey number 340/1. And for that, respondent number 3 has already filed a civil suit in the court below for the eviction of the petitioner. And there used to be a awful assault and abuse used to take.
So you have filed an eviction suit against them
In respect to some other property.
in respect of this property or not?
In this property, respondent number 3 is in possession and the said land is a barren land which is only used for grazing of the cattle. So there is no structure, there is no house, the amount of structure, some permanent structure needs to be there for grant of the electricity connection. But in this case, there is no construction of, so the grant of electricity cannot be permitted.
Okay. Another thing is that we have to see whether they are possessing the land or not. So you are saying that I am co-sharer, so I am in possession. That is your submission.
I mean, possession, they are also in possession.
There is some-
Property.
So they have electric connection there.
No, it is the agricultural land. I am engaged in dairy farming business. I am having the cows.
Okay,
I have constructed a cow shed there. I
Yes.
want electric connection in my cow shed for agricultural purpose, for minor irrigation, etc.
yes,
To use as a small pump, water pump, water pump, etc.
okay.
So I have applied
Applied, yes,
to the electricity department.
yes,
The electricity has given me a reply
yes,
that you give me a certificate from the agricultural department, that I have given.
yes,
And also give no objection certificate from the co-sharer of that landed property.
yes.
And they are the private respondent here. They are
Yes.
not giving, they have denied that in the affidavit in opposition also they have denied, we will not give the no objection. My submission is that it is a grant of electric connection for agricultural purpose.
No, what, you have brought this writ application.
Yes,
So why this is causing problem by them, the private respondents? They want to give the government authority, whatever it may be, engineer want to give you connection. So they are not saying that what fault what fault they have committed.
yes.
Yes,
My lord, can you see
they have sought for a document showing that the co-sharers have given consent.
My lord, kindly come to
page number 32, the reply given by the electricity department.
So
When I applied for electric connection.
no,
page number
if you are a co-sharer, you can, no problem. But
Page number
what,
32,
then
remarks,
go to the civil court. Why here?
No, page number 30, electric connection. my lord.
No,
Page number
electric
32
connection
remarks, upload NOC from the will did members. Will did, I have one.
Rejected. Application status is rejected. What is the-
Rejected on the
Yes.
ground that they have to upload the no objection. NOC.
Oh,
no
remarks
objection from the
upload
will-
NOC from the will, yes.
Yes, they are the will did members
So,
because they are.
This
the
is the-
co-sharer.
so,
There is a family dispute.
so what,
Other matter property.
whether this is a fault on the part of the electricity department?
Yes, this is a fault.
What fault?
Because my lord.
No, you go there to civil court. I am very much restricted in, everything is brought to the writ court.
When-
This is not
when
the
there is a
proper word.
document-
Go to civil court. That is my submission, Mr. Haldar. Yes, you will get
But I have
35
closed
minutes.
the deed of will, registered deed of will. I
Yes.
have already applied for the mutation on the basis of the will also.
Yes.
I am in occupation. my grandfather-
In our West Bengal, there is a provision in the rent control or something like that, that the rent controller civil code will give you permission, even they raise objection to get electricity from the. So why read code? Because superintendent engineer is saying that you are unable to upload no objection certificate from them.
Circular in this island, there is a circular to grant electric connection, even the person is not.
So bring your brother, I shall consult. He is not your brother, he is your enemy.
He's applying for my brother.
Electricity department.
Let it be tomorrow then.
Then bring
Let it be
it.
tomorrow, he's not present.
Okay.
Let it be tomorrow.
It the learned counsel for the respondent numbers.
3 and 4.
So have you filed any affidavit in
Yes,
opposition
it's fine.
today?
On Monday, on Friday.
Oh, already filed, huh?
Yes, on Friday.
You want to file any affidavit? The learned counsel for the respondent numbers 3 and 4 have already filed affidavit in opposition in terms of order dated April 2, 2025. Stop. Para. The learned counsel for the respondent numbers 1 and 2 is not present. The learned counsel, where are they? The learned counsel for the petitioner 6 for an accommodation. Please the matter tomorrow. Yes. না না এখন কল করতে হবে না, ডাকা হয়ে গেছে, কল করতে হবে। Which matter? 17.
For substitute service on the respondent number 12.
Oh,
As per leave granted by this court, I have filed that application.
you have filed application. Now you want to file.
Already filed. Today is a mistake. Carrying one of 2025.
Other respondents.
Other respondents appearing. One number 1 is appearing. 2 and 3 are could not be served. As per the report of commercial server, and
Hey, where is the petition? Hey,
I filed a petition for substitute service.
you have to submit the application to other respondents who are appearing.
He's not found for example.
Then
First class is not present.
please serve and come back. Not today. Then লিখতে হবে না কি, হ্যাঁ। Next. Here for the
Discharge.
oh. Yes, tell me.
You know, ordering the page number 86, my lord.
86.
86.
Yes.
They just raise the card before.
Yes, please.
The fact of the case is like this matter, this particular respondents, they are the bankers. As per the subsidy notification of the Director of Industries, the two of the accused.
You are the managing director.
No. No,
Yes.
one is the manager and another is the we are the bank managing director of
Bank of-
bank.
Managing director of
And branch
REM.
manager.
Yes.
This person.
Ah,
Who got discharged. The fact of the case is like this, my lord, a notification was issued by the Directorate of Industries. Wherein subsidy loan was granted in subsidies to the new entrepreneurs, small scale industries. So these two accused, Arm Location and Farida Bibi, they applied for the loan as per the subsidy granted by the Director of Industries. Director of Industries is also one of the accused in this case. They are facing the trial before the court,
hmm,
as well as this location and Farida Bibi.
hmm.
What had happened, my lord, during the course of their official transaction in the bank, these two accused persons, being the manager and the managing director of the bank, they have issued false statement in favor of this accused person, prime accused person. Due to which they were facilitated to get the loan amount. And the loan amount was transferred in the account of the accused person, rather it has to be transferred to the actual company of Chennai, where from the machineries were purchased.
Hmm.
Secondly, one of the accused got discharged. May I just come here on the back.
Discharged by whom? The Army court.
Where is the trial court?
The charge sheet submitted, not sent up or sent up? That's sent up. Thereafter,
Discharge
discharge.
was filed at the stage of charge and they were discharged in the case of prevention of charge.
Okay. Tell me, why the order is wrong?
Accused, my lord,
Why the order is wrong?
is what I'm placing the fact, my lord.
Yes,
One of the accused, he has transferred 70 lakhs in favor of.
please give the name. One of the accused. You do not- Are you ready?
Can it be tomorrow?
No problem. If Mr. Kobi is ready.
Ready. We'll do it tomorrow.
No, in the next week, previously you were
He
not.
was not there, my lord.
Available.
I was at the midnight, that's why.
Okay, the learned counsel for the state, CBI, has sought for an accommodation. Stop. This matter tomorrow. পরে দেবে।
The age of 123. Commissioner were appellate. During pendency of the proceedings from the restaurant is expired. And our last location, we are giving the names of the legal as a for three. File an application for substitution.
What is the number of the? Here, not today.
That the can has been filed.
Okay. Not today. Hmm.
Water 24. And okay, respondent engaged to his
But what is your other side?
Any reports
You are appearing respondent.
respondent.
The petitioner is not available. Not today. Not today.
If you are, please on 24.
You are appearing. Who is for this? So then not today.
Not 84.
Worship, I have got the petition. There was a direction to the other side to file opposition.
Have you filed
Yes, that's right.
today? Have you given copy?
Copy has been given today, but I have filed it only I got it.
So you want to file affidavit in reply?
Delay here,
Oh, okay.
section 5.
So we can take up. Are you ready or tomorrow?
Let's just go through this one and I'll come.
Hey,
And I'm probably, appellate.
Which was the respondent?
Nobody is appearing for you.
But I have already heard three matters, second appeals.
One was.
Yes. Mobilas Chandra Rai and Sukhoda Rai. Not today, করুন না কি করবেন?
Same position.
Not today.
Respondent states in here.
From item 22, madam, says that is appear for the petitioner. He is not in station, madam, as the.
He.
The last week he went where the not written back. So I pay for next circuit.
On the first day he appeared. Thereafter he did not. As per his submission, we fix this matter. The learned counsels for the parties have prayed for an accommodation. The learned counsel of the learned counsel of the petitioner
Petition.
has sought for an accommodation as his learned senior counsel is not available. Takes the matter before the next circuit. So you are saying so. কটা হলো এটা 32 হলো হ্যাঁ ঠিক আছে
Some matters again relating to discharge. The accused has been discharged in 33.
the same matters.
No,
Oh.
33, the complainant has filed a revision. In 34, the state has filed a revision.
So Jagjit Kumar,
This matter will take some time. Let it go before the next circuit.
the learned counsel for the petitioner has submitted that his senior counsel is indisposed of and he seeks for an accommodation. Stop. The learned counsel for the respondent, Mr. Kovid, has submitted that the matter may be placed before the next circuit. Stop. This is the matter. Before the available next circuit. Both the matters, huh?
Yes, yes, no, the tag, the revision 24 tags.
34.
Thirty-five minute, I'm appearing for the opposite party number 1. No, I'm appearing to the opposite party number 2. This is also a similar situation when discharge has been granted by.
And of course, the petitioner,
But state is the petitioner.
Sumit
Counterpart is
Kormakar.
appearing.
So not today or
I have discussed.
Place it- or next circuit.
The hearing matter will take time.
Okay. None appears on behalf of the petitioner. Stop. Mr. Kobi has requested that the matter may be placed before the next available circuit. Stop. List the matter in the month of June.
For the next available circuit.
That's the next.
Good.
Regarding that, both the, take instructions.
Which?
Regarding every cases, court order will apply or.
Okay, not today then. Not today. But they are. Huh? যেটা বলছে which item which
We have sought instructions for it.
yes got instruction
My lord, their instructions is my lord that because it is treated as a money claim, my lord, it is treated like that. This is how they have been doing it. Whether it is correct or wrong, my lord, that let them file an affidavit, my lord, then it will be.
Who will file affidavit?
My lord,
Your Lordship, for last
the
28
court
years-
registry,
Your Lordship, for last 28 years, I am practicing here and I have been filing MSCP cases. We are paying the fees in terms of the Court Fees Act under the heading application. We never pay
You are
for-
paying these rupees 20 under which provision of law? That is
Under the heading application in terms of Court Fees Act.
Court Fees Act, Court Fees Act.
Court Fees Act.
Sure,
Under
yes.
our regulation, nothing is mentioned about MSCP claims.
Have you considered this aspect?
the registry of the district court is disputing this.
Okay.
Orally, this is the instruction. I am not saying whether it is right or wrong. If they are saying something, then let them be compelled to put it on affidavit, my lord.
Let
Because
them know the law.
Who is appearing for the registry?
no, I am appearing under his instructions. He's representing the registry of the.
Oh, I see.
I've
Let
been
them
appointed as a
show
myself.
the law.
So you want to file any affidavit in support of his contention that the West Bengal Court Fees Act will be prevalent?
We have to.
No, according to his submission. Ad valorem.
Under the Bengal Court Fee Act also, there is no specification with regard to the court fee of motor vehicle claim tribunal. Because here also we are filing the court fee regulation, we have under regulation 1957. It's also not specified what will be the auditorium with regard to the MSCP case.
Now, whether West Bengal Court Fees Act is applicable here?
No,
Not
he's,
applicable.
what he's submitting is, one of the arguments that was raised is that in West Bengal, there is a separate column for motor vehicles claims.
Hmm.
But what the instruction received is that in West Bengal also, there is not a separate column. And it is being done ad valorem here on the basis that it is treated like a money claim because there is no separate column for that, no separate entry in the schedule for that. What my learned senior is saying, what Ms. Nag is submitting is that it should be treated under the head of application and fixed court fee should be levied. Now the hot instructions, this is what they are saying, my lord. Rest is your lordship may decide, otherwise
That's what I'm.
let this stand come on affidavit.
That's what.
Yes, file an affidavit
Let
then.
him file an affidavit, otherwise my lord, tomorrow it will be.
Everyone is.
No, I agree, so.
Hey, everybody.
They are taking adjustments.
This has
Last
been-
two circuits.
this has
they have
been-
No, I am very much.
What to do?
This has been disputed
I have
recently,
raised-
my lord, from last
Yes.
56 years, we are
We are
practicing.
practicing and Mr.
Similar
Rakesh is
thing-
also there. He is also
similar thing is
practicing.
going
in this
on.
court only. Can he say that it has
West
been
Bengal
produced for
staff
last
is
so many
not
years?
applicable here.
Why not say this of them?
Just this honorable.
No, file an
He
affidavit
will be in
tomorrow.
difficulty, that is why I am saying, because
Yes.
I am appearing as an amicus.
Position of law and any position of law has to be.
Is there in the-
My lord can, it will be for everyone's benefit, my lord.
No, okay, but I have to see that everything is in order. Otherwise,
I just don't want Mr. Rakesh
I
Kumar
have
to
raised a
do this.
decision.
Mr. Rakeshwar is representing whom? Administration. Her name is Satadru
No,
Chakraborty.
it's amicus.
Mr. Likhin, Mr. Rakesh Kumar has submitted that he will file an affidavit in support of the contention of the administration in this regard by tomorrow. Tomorrow it is possible.
They have been lingering.
I'm
it.
fine.
They should be ready with the opposition if they wanted to place it.
Please come. I want to hear.
Delaying the matter.
I will try my best.
You should-
Friday will not.
Friday? What Friday? What Friday? Thursday. No,
They are
day after two.
very, very. You show it. I-
Yes, the law point, only law point. And the what is the view of the administration also in this regard? Is there any law department or
Here,
anything?
ma'am, administration is not.
The law department is not.
If it goes to the administration,
Then it will be.
they will say that there will be a financial loss, my lord. I am only
Yes.
submitting as an
Yes.
officer of the court. So
Okay.
it is better
Sure.
not to get the administration because the
And
district
they are
court
not
is
concerned to it, my lord.
the administration is not concerned as such. The district
You
court
see-
is doing it.
You shall also consult the concerned court also. Who the court which passed this order, you also consult. Otherwise, what you have to gather views on which.
Actually, my lord, the registry of the district court should be made a party because they are the one who are implementing this.
Registry of the court. has-
Registry, no, not.
No, but they are.
The concerned court. This concerned court. One of
Yes, so that.
you
court-
take instruction or consult, make a consultation with them.
So who will file the affidavit? The difficulty is
What
that.
That is a difference.
Affidavit will have to be filed by the by the court the department who's implementing the this particular court fees.
Mr.
So let them be directed by.
After taking instruction from the concerned court. Yes, take instruction because it is his order. Okay, after taking his why he is trying to impose this.
Suddenly, after so many years,
This is-
this year it has been done.
So
Let us know, yes.
the relation between bench and bars always be good.
Because even I have been asking.
If there is any provision of law, what, yes, they will accept, they will accept.
No, I will pay the court fees.
Exactly. Please the matter Thursday.
Yes.
Please the matter Thursday, okay? Don't do it on the last day.
The return instruction will file, not because affidavit that will.
Bring. Written instruction will.
Written instruction.
Affidavit of order instead of written instruction. Right. Okay,
That will suffice.
you go and consult. You are the officers of the court.
Yes, Honorable High Court has passed order while not in the district court does not comply while not.
And I am also saying.
Let me communicate.
Okay.
In opposition, I will withdraw the case, I will pay the court.
Yes, no problem.
Because our, here, you know, the maximum court fee is 10,000 rupees. That is not an important thing. But unnecessary imposition is the.
Yes, anything else? Yes. He's coming from Kolkata. Which item? 38. 37. Yes. This is a 18, so 18. Holy angle social reforms. Yes. Not today করে দিন এটা।
Any arguments? In this case, response number 2, 3, 4, 6, 7 and 8 have prepared the affidavit, but the officer is coming tomorrow by 5. So,
Like he has already come.
I can give the advance copy to him, since they have come, I can give the advance copy to them. No,
Just when he will come.
tomorrow. Not today, I can give the advance copy to them. if they want.
What is the case? What is the case?
Your Lordship, this is regarding, I had sought for license of land area and.
It has to be written on the affidavit.
Just, I want to say.
Your Lordship, I had sought for license for sea area and land area. Your Lordship. For the marine project, Your Lordship, with regards to sustainable culture of marine pearls. I am a scientist, Padma Shri scientist, I used to work here, Your Lordship, previously. In the same land, I used to work through a company. The company's license was cancelled and it was resumed. The matter went up to the division bench. The division bench held in my favor to the effect that my credentials are not to be effective. I can apply separately and I can get license. So I applied for the license for both the sea area and both for the land area. Sea area.
Why is the division bench order?
Your Lordship, at page 56, Your Lordship will find the operative part should be at page 56.
56.
Page 56. Your Lordship, the operative part which concerns me, Your Lordship.
56.
Page 56, Your Lordship. Paragraph 36, Your Lordship. Having
56 of what?
of the description, Your Lordship, page 56.
11 to 56 কি আছে?
Page 56.
Sir, I only pray for not today. I can file the.
Just a minute, I want to, he has come from Calcutta as per our direction. Okay, yes, 56, no?
56, Your Lordship. Paragraph 36. Having considered Mr. Bhattacharya's submission, this judge holds that this order is limited to the correctness of the findings of the learned single judge with regards to the cancellation of license and resumption of the land, which was allotted to the applicant number 1 company, of which Dr. Sonkar is no more a part. Dr. Sonkar has not argued on the merits of the orders passed by the authorities. He is only concerned about the order affecting his reputation and position. This order is not a declaration on the personal achievements or failure of Dr. Sonkar. Dr. Sonkar's right to continue with any oil culture activity under the administration or under any other authority have not been decided in this proceedings. Thereafter, your lordship, I made application before, because this project, your lordship, requires both sea area and land area, which has to be adjoining. Both have to be adjoined in the same place. I applied for the sea area and I applied for the land area. Sea area, your lordship, they granted. I paid the license fee. I cannot continue my project without the land. They rejected the land area on one particular ground on the basis of a policy, a 2013 policy. They also recorded the fact of this particular case.
So sea area is given to you,
Given to me.
but land area is not
Land area
given.
they rejected on the ground of a particular policy, a 2013 policy.
Sea area means beach,
No,
not
sea
beach.
itself.
Sea
The
itself.
adjoining land of the beach, they rejected. The
Rejected.
DC authorities rejected. On the ground that there is a 2013 policy, that
But
2013
this
policy
matter
does
is
not.
not at all maintainable
Your
because
lordship,
that we want to
already
file
decided.
affidavit in opposition. I am for the CPA. I have not been given any direction to file. I am appealing first time before this man order.
I'm against the order of the deputy commissioner, your
Then
lordship.
why then
Yes,
we
represent-
are-
You will represent your lordship. If I may be allowed to place like
Just to want to know the
Fine.
facts.
your
So
lordship.
sea area, land area.
Sea area and land.
You have given sea area but not land area.
Land. On
Yes.
the ground that the 2013 policy, your lordship, does not allow for your lordship giving of any license to any individual. My respectful submission is in reading of the policy itself, which I have annexed, your lordship. That policy is not applicable to individuals. It is only applicable, not just individuals. It is not applicable to any private companies or the like. It is only applicable to government entities and where the government, one department, the land department of the government gives to some other government company, government enterprise and the like. The regulation, which is an act of parliament, your lordship, empowers the commissioner to give land to any particular individual under rule section 146, your lordship. They have the authority to give license to any individual.
Hmm.
They did not exercise that. Lordship kindly sees once the order for the sea area at page 76.
So there are two respondents. How many respondents are there?
Who responded?
Yeah,
One
I
is
think total eight
the
respondents.
total 8 department. I am for the
Number five.
respondent number 5, chief port administrator. And
Your lordship,
Mr.
chief port administrator did not.
Even Union
Your
of
lordship,
India is also not there. I don't know who that is.
Your lordship, if I may-
So from the record, it appears that we have given sufficient time to you, but in spite of
No,
that.
but Malad, I am appealing for the first time for this.
Oh, you are appealing.
Your
For the
lordship,
first time.
we
Malad.
do not have any, we do not have any, your lordship.
Only one day.
If I may, we do not have any kind of grievance against the chief.
So let us be explained.
No, we
There is
have,
some
we have
mission
given a
there.
party and because we have annexed that order, because
You
this,
will be there tomorrow.
this I'll be there, but your lordship, the thing is, if they file an opposition tomorrow, I'll have to go through that also. Then if I have to file a reply, I'll just sitting in the meantime, that particular land in question, because they have given us this area, the sea port management that my learned friend is representing, they themselves have by their order given me the sea area. Land area, the laboratory is there. I might have paid the.
Okay, I
license.
shall consider tomorrow, file the affidavit.
Yes,
One
lordship.
more thing, this matter has already been dealt in a separate matter. Its name is Ajay Kumar, the Pulsar merchant matter where company was
Already
made a
decided.
party.
That
That
is
is
not
already
your lordship, I've shown that.
Why is the copy?
You shall bring the.
Your lordship, I have shown
And
that.
it was in the
Your
affidavit.
lordship, they're referring.
Okay, please bring all the copy tomorrow and file affidavit in opposition. If necessary, you can file affidavit in reply. Let us see.
Yes.
Requires that I have to file a reply.
Okay, then I shall-
For some inching kind of.
I shall consider this
There is no scope
on
for
tomorrow.
protection in this.
That will be decided tomorrow, whether I shall give or not. Okay.
Your lordship, I shall object.
The learned, the learned counsel for the respondent number? You are respondent number what?
And number 2, 3, 4, 6, 7 and 8.
Has sought for one day's accommodation for filing affidavit in opposition. Stop. The learned counsel for the petitioner is present. Stop. Please see
I
matter.
am also praying for affidavit.
For number 5.
The learned counsel for respondent number
Number 5.
file
Your lordship.
has also submitted that he wants to file an affidavit in opposition.
And one melody doesn't appear, not. I don't think here, one is for Union of India, one.
Okay, list the matter tomorrow, we shall consider everything, okay?
Your lordship, if I may.
Yes, come from Kolkata, we have to see
I
everything.
also came from Kolkata, there is no.
Today, no, you are,
Today, I also
Your
came
lordship,
from
your
Kolkata.
lordship. One humble submission, your lordship.
Yes.
Chief, they chief court management, they had given us the license.
Okay,
Because we are relying upon that order.
Come,
They have given the license to company, not to the individual.
No,
My
no.
lord, can see the license.
okay, we shall see tomorrow. এই অমিত বিশ্বাসেরটা দিন তো।
My district concern, your lordship, my proprietor.
It's not proprietor.
Okay,
Password matter, sir.
হ্যাঁ অমিত বিশ্বাসেরটা দিন 14.
Your lordship, if it fixed at something like that.
After division bench I have to hold.
Yeah, yes, whenever your lordship is first sitting.
We don't know even whether
It was not even-
There are so many parted matters.
Your lordship.
I shall try to hear you. Don't worry. I shall give it in a reasonable place. Okay? Hey, Amit Vishwas. Come back tomorrow. We shall consider everything.
Tomorrow is also a resolution in the main page.
Bar from bar library and bar association.
But due to the passing of honorable justice for
They doubted that, then
I don't know whether.
Yes, Amit Vishwas, what happened? Why you have not come? আপনি এলেন না কেন? আমি কালকে আপনার নাম ধরে ডেকেছিলাম।
হ্যাঁ স্যার, কালকে তো স্যার আমি জিজ্ঞাসা করেছিলাম কোর্ট বন্ধ বলে এরকম আমাকে বলছিল, এই জন্য আমি আমার শরীর খারাপ স্যার।
ঠিক আছে, আপনারটা আজকে হলো না, কালকে যদি হয় হবে। হ্যাঁ ঠিক আছে
স্যার, করে দিন স্যার, একটু দেখেন স্যার, আমি পরেশান হয়ে গেছি স্যার।
ঠিক আছে, নট টুডে, এটা এই অমিত বিশ্বাসের নট টুডে করে দিন। হ্যাঁ আগে মিস্টার কুমার,
7 and 8, Mr. Sunil is not.
which one? 7 and 8.
Nine, my lord, it can be taken. I wait for expeditious disposal of the civil.
Who is for the other side?
It's a civil division.
Last man.
It's an execution.
Last man.
29 goes on.
Your lordship, I'm appearing for the petitioner, your lordship.
Is it 39 or WPA 122? WPA 122.
Yes. WP 122.
What happened?
The respondent has not filed their affidavit in opposition yet. I believe they will time to file their affidavit in opposition.
But why is the respondent? Nobody is,
Babita ma'am is appearing for the respondent.
I do not see anybody. So not today.
I think 7 and 8, my lord.
Not today. এটা
Only item number 9 can be taken. It's an execution case. I have filed before the civil judge senior division, my lord.
what happened?
My lord, execution case, my lord, the dates are being given after.
Item number, item number? Item number 9 বলছে দেখুন তো। Item 9, এটা কি টাকা হয়নি তখন, না 500 বার নিয়েছি?
Number last one.
হ্যাঁ, what happened?
My lord, here I have filed an execution case on 19th of November 2024. My lord, can you see the order sheet?
Spirit trial of other execution case, but why so you have filed after 2 years
No, my lord.
of decree?
What happened?
After 2 years of decree you have filed execution case?
No, what happened? They have preferred an appeal.
Hmm.
Appeal was dismissed in the month of June.
Then 2 years have passed.
Yes.
Then you have to serve
I am
upon.
ready to sir, but my lord, can you see? The case was fixed on 18th of December. Thereafter, next date was given on 7th of March. Thereafter, now the date is given on 21st of July 2025. My lord, the Supreme Court repeatedly said execution case has to be disposed of within 6 months. My lord, can you see this latest judgment of the
Now,
Supreme?
whatever it may be, but you have made a party, Dr. Sita Cherian, unless he appears here, how can it be?
My lord, only my lord, direction may be given because I will serve that. Now the date is fixed on 21st of July. My lord, kindly.
So you have to perform, you have.
Dispose of within 6 months in terms of the direction of the Supreme Court passed on 6th March 2025. My lord, can you see?
What is this?
The Supreme Court judgment which says that it ought to be disposed of.
Related to this case?
No, not this case.
Oh.
Supreme Court said whatever execution cases are there, that has to be disposed of within a period of 6 months. My lord, can you see paragraph number 73?
But have you tried to serve?
My lord, this
Upon a
is civil division, my lord.
So in the civil division, nobody.
My lord, two things are there. First of all, unless and until it is admitted, it cannot be served. Second, my lord, I say, my lord,
So there is no
What is my prayer? My prayer is that if my lord direct the lower court to dispose within 6 months by preponing the date, I will serve there and he will appear there. Because already there is a direction to serve him. in
Okay.
the Lower court. I am ready to serve, but my lord, I am aggrieved by the.
Oh, I shall
Delay,
go through the
My lord,
judicial
that-
decisions.
My lord, page number 73 onwards.
Page number 73 onwards. I have to go through the record, judicial decision, then I shall
Yes,
decide.
my lord, the court specifically said within 6 months. And
Okay.
directions were issued to the lower court also, my lord.
Okay.
Subordinate court,
I
I'm
will
sorry,
see.
subordinate court.
Okay, I will see.
It can be disposed of, my lord, by giving a time frame.
Okay.
And my lord, the other matter in my absence, they have made some submission is required.
You have already given a entire law points, I think.
My lord, may kindly consider it, my lord.
Certainly.